Hey guys, we are back with microphone. It's showing that it's working in StreamYard, so my bad on that. But we are going to be looking at a Courtney Clenney hearing from the 18th, so 2 days ago. I haven't watched it yet, but I know we're going to hear from a medical examiner. We're going to get some knife throwing demonstrations, so that's going to be interesting. And we're also going to hear some other motions argued. Now, the next update, just so you guys have a peek at what's going on, there's going to be a status hearing on November 15th. I have requested the most up-to-date exhibit list, and I've also requested the newer amended witness list. So they're really quick, the Miami-Dade State Attorney's Office, with responding to stuff like this, so probably you'll have that Monday. And before we had to restart the stream, still don't know what happened. I did mention, if you missed the community post or my post on X this week, earlier, well, over a week ago now, Courtney Clenney had filed notice of intent to rely on battered spouse syndrome as a defense. So, in other words, one of the justifications she's going to put forth for what happened on April 3rd, 2022, is that she had a reasonable fear based on past experience with how the victim in this case, Christian Obumseli, may have been previously. In that moment, she's going to argue that she had a reasonable fear for her life and safety based on past behavior. We'll have to see what she argues is the overt act that made her in fear at that moment. But yeah, I haven't watched this hearing. We'll do it maybe like 1.25. There's a decent amount of dead space. And unfortunately, there are no closed captions. So we're going to have to try to hear. This audio isn't the greatest in this courtroom. But we'll have to see. And shout out to you guys for coming back in here after I broke the stream. Hey to Steph. Hey to Rhea. Hey to Ariel. Good morning to Jess. And here comes drama. Yeah, I think we might have some drama coming. Mr. Man says, hello, people. Rhea says, spitting at Spur with my kid's butt. And then Sea Travel, that's right, hit the like button. And Legal Vices, 1000%. Hey, Sarah Boone is trying it too. So can I. Good to see you, Legal Vices. Dennis, my military mind. Kristen, you guys are all finding your way back here. Let's get started here. You'll see a lot of downtime. The camera just panned on Courtney and her attorneys in the beginning.
Good morning, this is Courtney Clenney, Captain Hope, and Sean
Good afternoon, Your Honor. Chief Prosecutor Mickey Ratson.
We're going to have to yell to use the mics, guys. The audio's bad in this courtroom.
So we'll go ahead and get started. Mr. Casciademo, my understanding is you want to be heard first on the motion for reconsideration?
Yes, Judge, thank you. I appreciate you accommodating me. I know we've got a lot of attorneys and moving parts, so just so we weren't getting in the way of everybody's schedule, and we're trying to squeeze a couple things in. So thank
I
you.
will allow you to argue it briefly, but I did read through it. I read through the civil case that you cited. I don't think it's analogous. We have yet to cite any criminal cases, but I was going to let you argue
So thank you.
of appeal.
Yes, Judge, I appreciate
About
that.
what I'm probably going to
I
do.
will.
Go ahead.
I will keep it brief. I know that motions for rehearing and reconsideration are not always the court's favorite. So
No, it's
again,
fine. I mean, I think that it's fine up to this point. This is the time.
I'm hoping to not have to, Judge, but the leading from the court is not going to be over the confidence. So let me do my best, Judge, if I may. And again, we appreciate that. So part of the reason why the court doesn't really see any criminal cases is because it's a civil rule of procedure, and generally it applies to, as the court pointed out last time, physical property. We're talking about data here, which I think is a pretty unique issue. Here's where the issue on intervention, I think the problem is with the court's analysis. We've all agreed, and that's a rarity, especially in these cases, for us to have an agreement, is that the plain language of the rule governs. The court, in its denial of our motion, employed this two-pronged test. I don't read the rule that way. The rule says that the intervention shall be in subordination to the main interest, and we can concede that the interest we're discussing is the state's right to investigate and prosecute Courtney Clenney. There is nothing in the plain language of the rule that precludes the intervention based upon the intervener's status. So we disagree with this two-pronged analysis. But let me say this, Judge, because I know the duty of candor of the court, and if the court retains its position, yes, it is our intention to seek a review of it. So I think it's important that I point out that in my review of the case law, even if I'm correct, which I may not be, the appellate courts will still look to the more substantive issue and consider the court's ruling on the intervention itself to essentially be a harmless error. It's kind of akin to a tipsy coachman analysis. So I think the bigger issue and the better use of my limited time is to discuss that issue of subordination. And I think I did the court a disservice at the last hearing because I did not draw enough attention to the Florida Constitution, and in particular Article 1, Section 23, which is, as Your Honor knows, the section of the Florida Constitution that in its own right creates a privacy interest. That is unique, and just again, Judge, for purposes of the record.
Because I do think that it is an issue that is more, well, go ahead.
Okay, so Judge, again, because we are talking to the record now, let me just be sure that, yeah, so let me cite to Article 1, Section 23, right of privacy. Every natural person has the right to be let alone and free from governmental intrusion into a person's private life, except as otherwise provided herein. This section shall not be construed to limit public's right to access to public records. More importantly, Judge, I'm going to cite the court, and I know Your Honor did read our pleading, but Winfield v. Division of Power Mutual Wagering, which was 477 Southern 2nd 554. It's a Florida Supreme Court case that discusses Florida's unique privacy right and its unique interest in the Florida Constitution. This is, and I'm quoting now, Judge, this amendment is independent, freestanding constitutional provision which declares a fundamental right to privacy. Article 1, Section 23 was intentionally phrased in strong terms. The drafters of the amendment rejected the use of words unreasonable or unwarranted before the phrase of governmental intrusion in order to make the privacy right as strong as possible. And that's why I'm back before Your Honor, because I am having trouble understanding how the court is reconciling the warrant as it is with Kim and Deborah Clenney's very, very robust privacy interest. I will concede, Judge, the state has an interest, and not a small interest either, Judge, in prosecuting Ms. Courtney Clenney. Kim and Deborah Clenney are not charged with a crime. The reason their data is even subject to that interest is because they are related to someone charged with a crime. Florida's constitutional amendment protecting privacy doesn't allow for that. Now, there is a compromise, Judge, and there is a way that this court, with its jurisdiction, can address this issue. So, again, as I was saying, I was having trouble reconciling the denial and the data that's in the court file with that constitutional amendment. However, given the breadth, both in scope and time of the warrant itself, I think it's incumbent upon the court, in consideration of Article 1, Section 23, to narrow that. And let me put a finer point on that argument, Judge. The state has pointed to 3 separate instances of what they think they are going to find in this data, and why it is relevant to the prosecution of Courtney Clenney, and why they should be allowed to go through 3 years of iCloud data of 2 private citizens uncharged for the crime. First, they say that Deborah Clenney may have been on the phone with Courtney at the time of or in close proximity to the death of Owen Sugg. I'll concede that point, Judge. If it's true and the state can support that in an affidavit, then we know when the death happened. A narrowly tailored search warrant or subpoena for that data is perfectly appropriate. The second issue, they pointed to photographs that were voluntarily turned over to the state to show the abuse by Christian Ogunselli of Courtney, and have argued that there are gaps in the images. Again, the time, we know when that happened, easily searched, easily collected, and certainly within their interest to prosecute this offense. And the third argument that was made by Mr. Quinlan at the last hearing, and that we've heard before, is that Kim Clenney in the Arthur hearing testified to something about commingling of assets, and Mr. Quinlan's exact argument to the court at the last hearing was that, and this is I think on page 29 of the transcript, Judge, that was indicia of risk of flight. Okay, here's the question for that. The Arthur hearing took place in November of 2022. Why would Mr. Clenney's testimony and the state's concern of risk of flight after Your Honor pretrial detained Courtney be relevant to a warrant that was issued a year later? So that begs the question of the legitimacy of what they are looking for. Let's assume in argument that those points are all needed and they're essential to their job to prosecute this case. Very easily, narrowly tailored. There's no reason why Mr. Clenney saying that there may be commingling of assets should open up his financial records from 2-3 years prior. Should allow the state to look into medical records or private photographs or private spousal communications. And what's preventing them, and what I'm arguing to Your Honor, and again asking you to reconsider the position and find that compromise, is that Florida specifically tells you they can't. The constitutional amendment is there for a reason. Not every state has a specifically enumerated right to privacy. Florida not only has one, but an incredibly robust one, telling this court, hey, government has an interest, but that interest does not trump a constitutional right. So you have the answer, Judge, and that's what we're asking the court to do, is to say to the state, hey, you don't need Mr. Clenney's medical records from 2020. You don't need Deborah Clenney's photographs from 2021. These are the things you told me you're looking for. Bring me a more narrowly tailored affidavit and warrant, and I will review it and sign it if it's appropriate. That is the compromise, Judge, that allows the court to exist between the state's interest in prosecuting the case and Kim and Deborah Clenney's extremely robust privacy right.
I don't have any more argument on the court has precise questions. I would point the court to the rule of motions for rehearing. The rule strictly provides that the motion will be filed in 10 days. The motion was filed in 16 days, so these time barred from rehearing on the court's matter. And as it pertains to the constitutional argument, I agree that the Florida Constitution provides the right to privacy. The second clause also allows the state to apply for warrants, which we already have done. Mr. Facadomo's recommendation of a compromise for us to do something we have already done was obtain a warrant for the court by all the clause. Therefore, the court is not going to come.
All right, so I'm going to go ahead and allow for him to report on the notes past the time limit. Again, the only thing that is cited in your motion are civil cases. This is not a civil case, this is a criminal case. I did my own research. I could find absolutely nothing that is analogous here, and I think there's a reason for that. I don't want to be the one to set the precedent for looking through every single search warrant that comes before me because somebody is going to put forward the right to privacy. That would exist in every single search warrant for every single thing that the state gets a warrant for. Listen, if the third overturns me, great, they overturn me. Let them do that balancing test between the constitutional right to privacy and the right of the state to pursue its investigation of its warrants. I'm not going to be the one to set that precedent. I don't think that is my job. I don't think that you have the right to intervene. You have an interest in the case, but I do not think you have a right to intervene. I did all of my own case law research on this. The only thing that I found were victims who were coming forward intervening in cases because there was a violation of Marshall's law. This is not this. They are not victims in this case. If the third wants to carve out its own balancing test between the constitutional right to privacy and a judge determining what parts of what was already determined to be a valid search warrant that was drafted by Judge Wilson, if the third wants to do that, they can do that. I am not saying that precedent. Okay, so it's
Thank you, Judge. Just to clarify one point, so the court does have that responsibility under 933 to review each of those warrants, and Judge Wilson actually renewed Judge Cabargo's warrant. So just
at this point in time, there was already a warrant that was off the probable cause. There is a privacy interest everywhere. I'm sticking with my original ruling. I think that it is the correct ruling. I think that I used the correct common test. Again, I can find nothing analogous. I think there's a reason for that. However, at the third, if you want to take it up to the third, I know that this is final order and is approval as of this moment.
okay, so this is the court's order orally pronounced.
Yes.
Thank you.
Okay, and if you want to make a brief order saying it's denied, and I will incorporate by reference the transcript for the case. Okay?
Thank you.
All right, thank you.
So I believe right at the end there, she said quickly she'll get the transcript. Now, Jude Facadomo came into play in this case when it came to the laptop charges. So those have been dropped by the state attorney's office after a big back and forth. They were trying to defend themselves against a potential attorney-client privilege violation, and the judge found that the state had violated attorney-client privilege. So right after that ruling by the judge, the state attorney's office said, all right, we're just going to drop these laptop charges. Jude Facadomo has been trying to get devices back from the state, as well as he's filed motions previously, like a couple months ago already, asking the court to intervene and stop the state attorney's office from being able to look through some of the things that the state was able to obtain through the search warrants in the laptop case. So not just the devices themselves, but also Apple iCloud accounts belonging not just to Courtney, but to Kim and Deborah Clenney. So Kim is dad, by the way. His name is Kim. And judge denied that there. She said she doesn't want to be the one to set the precedent to have to fine-tooth comb through every search warrant that comes across a judge's table. But it seemed like at the end there it was muffled. She's going to get him a transcript knowing he's going to go appeal this in the interest of privacy protection. So that was that. We probably won't see much more of him today at this motions hearing. It'll focus back on the homicide case.
Yes, sir. Can you give a copy of the state's motion to strike?
Yes, good morning. Good afternoon, Judge. Frank Over back to this evening. We have 22-14167 case along with my co-counsel, Ms. Sabina Puglisi.
Oh my gosh, the microphones.
Motion to dissolve and have a motion to strike. I'll be a little brief. I tend to agree with the statement that there's no basis for a dissolution. However, I treat it as a motion for consideration. Should that draft as motion for consideration subsection 947.041 subsection 5K versus N. I don't think there's anything even in the motion that talks about a subsequent event. There's nothing there. What's your subsequent event? There's not one. But,
Camera
we
person.
talk a lot about
The
why
camera.
I should consider it based upon this is unknown at the time of both the ARPA hearing and the confidential motion. There was no discussion of the ARPA hearing and the motion to dissolve. I mean, I did make a finding based on the Florida Constitution ARPA hearing as well as the pre-competention statute. So even if I were to reconsider the pre-competention statute, are you also asking me to reconsider the ARPA hearing ruling?
Judge, the rules allow for the court to take into consideration a 3.132 subsequent events. I hear what Your Honor is saying.
Well,
but
first of all,
we
are
do
you
have-
also asking for me to reconsider the ARPA hearing ruling?
Judge, we know that you've made a finding of prevailing presumption rate, but the phase 2 arguments are what
That was my bad. I was trying to look up.
we're readdressing, which is permitted under the bond statute.
This guy's name is Sean something.
3.132 sub C.
Okay, so you are asking for me to reconsider the...
Just the part of Your Honor's ruling that coincides with Your Honor's ruling under 3.132 pretrial detention, because those two, Arthur and those two obviously are very intertwined.
Okay, so what's
She
the
wants some
subsequent event
bond.
that you think that it qualifies as for dissolution?
Sure.
Subsection N.
There's several subsequent events. The term subsequent event is not defined in the rule, but there are subsequent events such as this discovery of the body on camera of an eyewitness showing the abuse that Ms. Clenney faced. That is a subsequent event that presenting that to the court, finding that discovery.
So you
Listing
think that that's evidence that was unknown at the time of the hearing?
correct, but I believe that's an event. I don't know how you're defining event. I think that qualifies as an event, along with the listing of expert witnesses in this matter. Your Honor considered, I think.
The listing of expert witnesses is a subsequent event?
The discovery from the expert witnesses there,
That's a subsequent event?
yes, Judge, specifically, you are finding there's a substantial probability that she committed the crime, okay? And what we are showing the court is that she's justified in her actions when she acted in self-defense. Now, we've made that argument at the appellate hearing and the detention hearing, and the court said that you didn't find there was sufficient evidence to believe that. We now have sufficient evidence, which is a subsequent event, and that's what we believe, because there's no case law to really, there's no definition in the rule that tells you what subsequent event is. So we do believe that that falls under subsequent event.
I'm going to let the state address that.
So Judge, for one, I do not believe, and the state will stand on the premise that that is not a subsequent event, an event that the defense is creating. And in this specific case, it's an experiment created by the defense to throw knives at a pig carcass. To create the general premise that it is possible that this defendant could have thrown this knife. So one, the factual scenario itself would not rise to
really a consideration against the dangerousness of the act itself. But even then, the subsequent event, that isn't a subsequent event. They created the circumstance that isn't factually supported by any of the evidence in this
Let me
case.
give you a definition of subsequent event. Subsequent event is if you have victims who are living near, in the country and then move abroad. And that moving abroad means that the person's not a danger to those particular people. That's a subsequent event. Somebody getting a terminal illness and or becoming paraplegic and therefore not being able to travel, that's a subsequent event. Discovery issues and the hiring of expert witnesses, that's not a subsequent event. You can go to motion for reconsideration. That's why there are two prongs in the statute, reconsideration and dissolution. Dissolution means it should be dissolved because, in quote unquote, let me go to subsection, what is it, N? Because the subsequent event has eliminated the basis for detention. That's not what any of these are, okay? So that's not what this is. What you're asking for is reconsideration. Your creation of a video from an expert witness or your discovery of the body
Expert witness, a video from the expert witness, guys. We're gonna get knife throwing demonstrations.
on camera for somebody that you didn't know existed at the time of the pre-trial detention motion, although I know that it existed, but maybe you had seen body worn camera. None of that is a subsequent event. So nothing that is a basis, and I went through your entire motion, nothing is a subsequent event. However, I'm not going to strike it. I'm going to treat it as a motion for reconsideration, okay, under subsection K. All right, none of those are subsequent events, and I'm making the finding that they are not subsequent events. Nothing that is listed in your motion is a subsequent event. Okay, so I'm not dissolving anything, however, I will reconsider them. Okay, so we're moving on to reconsideration. We can discuss what it is that you believe that I should use now in an analysis for reconsideration, both of my ruling for the Arthur hearing as well as my ruling for the pre-trial detention motion. Go.
We have evidence to present, Judge, in the form of Dr. Maricini.
Okay. All right, so would you like to call him as a witness?
Yes, I just have to see if he's here because we were set at 1:30 actually for this, so I told him to be here at 1:30. We can go through our other arguments, though, Judge, before we get to that, though. We have other evidence to present. Oh, okay, he's here, Judge. What would you like him to say? Yeah. And the only thing, Judge, is I had the whiteboard, he had asked, his courtroom is so it's hard to even, I tried to even bring it in, and it's very hard.
They don't have room for a whiteboard in the
Yeah,
court.
we don't want
It's
to-
too tiny.
Nope, we'll be able to fit it in here. Is it possible for him to sit on that chair instead, Judge? Is there a microphone or no?
There's no
Oh, there's no, okay, because I was gonna say it might be easier to just leave that whiteboard there. Mhm. Yeah. Should we have some additional evidence to introduce? One is a clip of the video of Dr. Maricini during the demonstration. I believe we sent that to you, right, Judge? Okay, so I was just going to have him walk through that, what he was doing during it. I'm going to have to show it on my laptop, though, because we don't have a TV screen. So I'll just put it close to him where you can see it as well.
And I will allow you again. You can show me whatever you want to show as a motion to reconsider my previous decision. I have already looked at most of what you sent, which includes the videos, body worn camera video, Machini, and then the microphone guy.
Dr. Gray. I'm sorry, Mr. Gray. I'm just, Dr. Maricini is also a microphone.
All right, so super quick background on Courtney Clenney. She was an OnlyFans model. She had recently moved to Miami, this expensive penthouse, with her boyfriend, Christian Topi Opumseli. They moved there in January of 2022. By April 3rd, 2022, he's no longer on this earth. She claims that she was 10 feet or so away from him. In their kitchen, she was kind of going towards the living room, and she flung a knife at him because she was scared and wanted him not to come any closer to her. So she's on trial. She's charged with second-degree murder. She also, obviously, that knife is part of it. She's asserting self-defense, and now she recently filed an intent to rely on battered spouse syndrome, which could be, if that's allowed, that could be a way for her to argue prior bad acts, character evidence about the victim more easily. and we'll have to see what their angle is here. It sounds like they want to argue for pretrial release. The judge isn't really with that. The medical examiner that the state called said the single wound, knife entry to the subclavian artery, looked like it was plunged down, meaning she was up close to him rather than standing from the room and throwing it. We'll see.
Yes.
There's another question I have is the video that Your Honor saw, was it a singular video?
It's the same one you showed me. Yeah, that's right.
So the throwing of the knives towards the cover.
That was one done, the other one was checking.
Okay.
All three videos of body worn, my throwing, and Dr. Baranchini with his.
And we can clip them down there.
Oh, yes, it's just really good call, Dr.
Right, Dr. Baranchini, if you could come forward, I'm gonna have you sworn in.
Yeah, that's their camera feed that's doing that, so I don't know why.
And I have Mark.
You swear from here that you're about to give nothing but the result of that?
Good afternoon, Dr. Marchini. Can you, did you introduce yourself to the court already?
No, my name is Dr. John Marchini, M-A-R-R-A-C-C-I-N-I.
Okay, and very briefly, I just want to go over some of your experience as a medical examiner. Let's start just with your education.
Judge, I think we can stipulate to his expertise.
Perfect. Great. Okay, so we would have him as an expert in the field of forensic pathology, clinical pathology, and anatomic pathology, and which of course are not sure.
Absolutely agree with you, all these things.
Great, thank you. Can you tell the court what you were retained to do in this case?
Simply put, I was asked to investigate and review evidence as to whether a thrown knife, specifically the knife involved in this particular case, could penetrate and inflict a wound found on Mr. Benson.
And did you review various documents in making your determination, prior to making your determination?
Sure, I reviewed the complete work product of the Office of the Medical Examiner, including
Yeah, there's stuff there that's on both.
I reviewed the complete work product of the Office of the Medical Examiner, including but not limited to the autopsy report, the autopsy photographs, and miscellaneous notes. I reviewed police reports, some police statements, some videos associated with this, and then we conducted some research collectively with a knife throwing expert named Bobby Branton. And after the conclusion of these different things and the review of other evidence and statements, I formed an opinion regarding whether the knife could, if thrown, penetrate and inflict a wound as seen on Mr.
Let me ask you this. Did you review crime scene photographs?
Yes, I did.
What about the Arthur hearing transcript of the testimony of Dr. Hutchins, who is the medical examiner of the state?
Yes, I did.
What about the crime scene, the documents including the floor plan, the report and floor plan?
Yes, I did. All of those things.
I believe you said the medical records from the trauma center. What about the fire rescue reports?
I did.
Okay. Did you review Ms. Clenney's statement to the police?
Yes.
And did you receive, or did you look at any of the knives in question? And I don't mean the specific knife that was used in this case, I just mean the type of knife.
But I've asked the defense team to proffer an identical weapon so that that weapon could be looked at and recognized and tested with. This was done both with myself and with Mr. Branton and so forth. And then there was some testing which has been video recorded of the knife being thrown. I made arrangements to select a suitable biologic material. And what we finally settled on was using a side of pork, essentially.
How did you make that determination?
Pardon me?
How did you make the determination to use side of the form?
Well, I wanted mammalian tissue with skin and muscle and other structures similar to the human body in the general area of their structure. So we didn't need to go through bone, but we need to have a part of the pig that would have sufficient muscle, fat, fascia, and so forth, with skin.
Now, and I know you're not here qualified as a knife throwing expert. Do you have any experience throwing knives?
Well, I've been an amateur knife thrower for about 30 years.
And did you yourself try to throw these knives in this case?
I did.
Now, did you participate in a demonstration that was done with Mr. Branton throwing the knives into the pig carcass?
Yes.
And can you just describe what your role in that was?
It was primarily to determine, after the knife was thrown, to examine the penetrating defect and to see if the strength, resiliency, and other features of the tissue was similar to human tissue in the cases where Mr. Bunsen was struck, which was the upper pectoral area and the deeper.
Now, how the demonstration was conducted, and I mean specifically how far distance-wise the knife was thrown, that was something made by the defense, right?
Right, the defense proffered and communicated with Mr. Branton about what they wanted to do.
And you have no knowledge as to why or how that number was picked?
No, I don't.
And I mean, just to be clear, you weren't present on the day of the scene, so you don't have any specific facts about what happened on the night of April 3rd.
Why is Prieto like hugging? What is he doing back here? Just holding it still?
Okay, so now going back to the demonstration, and what I'm going to do is, I'm going to play it for you. We don't have a TV, so I'm going to bring this to you, and you can state your message. Here's the TV. Yeah. Oh, okay. Okay. Mr. Prieto is going to try to bring the TV in. Okay, so in the meantime, we'll just keep going. Let me just ask you this. What is your opinion in this case?
The thrown knife, such as identical to the one used in this particular case to inflict a lethal wound, could have been thrown and inflicted said wound.
And when you say could have, can you be more specific as, I mean, can you say percentages? Are you able to do that?
Well, I mean, the simplest way to divide between whether or not it was directly thrust into someone using the hand to use a leg or whether it's thrown, and we can use penetration. This particular knife is very short, and getting to the skin, it gets to the skin very easily. Most knives only require 6 to 12 pounds of pressure. So, a human being with even average or less than average strength could easily drive this knife almost 6 inches. But the actual penetration of this knife is around 3 and 4 inches. So, also there's no hook on the foot. And so, these knives,
Can I stop you for a second because I didn't hear, I'm sorry. There was no what?
no HILT mark. In other words, when a knife goes completely through to where the handle is, it sometimes leaves an interface mark where the blade meets the handle. That wasn't present. So at the end of the day, I favor it being a thrown knife rather than it being a directly inserted knife as in the usual stab. The difference in penetration, in my mind, is one of the decisive factors that favors one over another.
And what about slippage, where there might be marks on the defendant? That can happen if a person is using a knife, right, to stab somebody?
Right. I mean, a knife that does not have what we call a hilt guard, which is like a cross piece to the blade, it's pretty easy when you drive a knife to, your hand to slip up onto the blade edge. None was found.
Did you review the photographs of Ms. Clenney's hands? Okay, and you didn't observe any kind of damage to her hands that would be the result of slippage?
Right, there were no cuts.
What about any defensive wounds? Did you, in your review of the photographs of Mr. Almoncelli, did you see any defensive wounds on him?
I did not.
What, if anything, does that tell you?
Well, usually defense against knife, you see some cuts in the hand by the person who was receiving a knife assault with the hand, holding the blade and inserting. So we just didn't have to see any in this particular case.
And I know that you wanted the whiteboard for a reason. Was there specific, wanted to show the court something?
Well, I mean, if necessary, unless, I probably would get it, so I probably would use it.
Okay, was there something specific?
Well, I
Just to
would
make sure
just,
you
I would just, show a trajectory of the flow, not just for purposes of our discussion. And some other things that might be pertinent to the defense there.
Okay. What specifically would you think is important for the court to understand that goes towards your opinion in this case?
Well, there was a proffer of our defense that at some point in time, there was an altercation immediately preceding the knife event. And one of that proffers was that the defendant was assaulted by means of an arm going across the neck of Ms. Clenney by Mr. Rosen. And so the question was there any physical evidence from the examination of the neck of the defendant in the photographic evidence in this case that found to be there?
Judge, at this time, I would, do you have an objection to it? I can find it. Yeah, you're okay.
Can you talk about whether or not these are the two pictures that you reviewed?
Yeah.
I don't have any questions.
Let me watch the mark. No, I can't, so. If I push it. Take a look at these two photographs, let me know if you review those.
And shout out to Raymond Rohrer here. Super nice of you. I'm a quantified expert watching YSL coverage. Right, we've got more experience out here than someone like Detective Dennis. kattnotwilliams is the best, including her chat subscribers. We can push her over 40K subscribers if we like. Now that'd be cool, but guys, I'm so scared of the chat being way too crazy because like moments like this where I can see what you guys are saying is really nice. It's really nice. Thank you for the super, Raymond.
I'll show it on, I'll have to show you on the screen because it actually comes out better than if it's printed. But you said that you have seen those?
Of course.
Okay. I would move without objection, the defendants A1 and A2 for identification into evidence.
A1 would become defense A, A2 would become defense B.
Can I have a moment and I'm going to put it up on the TV here, please?
Can you move the whiteboard and see kind of feedback from the
Oh, okay.
The way it's like a traffic jam to get the whiteboard and the TV in and out. Oh man.
I'm showing you, I believe this is it A?
A1, or not, it's A.
It's defendant's A. I'm showing you defendant's A. This is one of the photos you said you observed?
Correct.
And what, if anything, do you see from this?
Got the missing nail on the one finger. Red knuckles, swollen knuckles.
All right, well, this is a particular picture. There's several pictures of the because this is one of many. And some of the other pictures showed it better than this, but there's a faint blue-green discoloration here and some faint reddish discoloration here. And, when we see that, it doesn't prove it because it's, obviously it's a vague finding. But nevertheless, when we consider whether some pressure might have been applied to the front of the neck at some time. And then on the hands, of course, there's blood on the hands, but there's also some bruising, and it's better seen on the photographs actually, where her arms are down to her side.
I'll show you Defense Exhibit B.
Okay. So what we have is some bruising here, some bruising there, and there are some other pictures where her hands, as you see the knuckle side, and you can see some discolorations there. The probative value of these are more difficult because I'm not quite sure the age of these. I can't say that this occurred immediately before the lethal event or not. But nevertheless, what you have is you have some bruises on the arms, you have some bruises on the knuckles, and you have discoloration in front of the neck. And that only came up primarily because of the defense theory that there was some physical interaction preceding the lethal event.
Okay, I'm going to go to the demonstration now that,
He said that there were other photographs that he looked at that showed the neck better. Was there another photograph?
we try to pull them out.
It's about a half dozen
There are
photographs.
quite a bit. I will see if I can look at some additional ones.
All right, go ahead.
Okay. Going to the demonstration, Judge, this is a digital evidence, so I have a USB to give to the court. Well, how would you like to know
What is on the USB?
There are 3 videos on there. The first one will be the video where he looks at the demonstration. The second one is Mr. Bratton doing the neck and the third one is the
Typically, we do it as 3 different USBs. George, how would you like to do that? Because it's all 3 videos on 1 USB.
If they give me 3 separate USBs, I would do that.
Okay, can I replace this one?
Yeah. So let's just go ahead and name which video is going to be each item of evidence, and then we'll replace them with 3 separate USBs.
The first one would be, and I'm using the C1, which would be,
They're going to be entered? Those figures?
will be the video demonstration with Dr. Mertier.
That's going to be defense A3 will become defense C.
The next one will be a knife throwing demonstration video by Mr. Bratton.
A4 will become defense exhibit D.
And then the next one will be a body cam statement.
A5 will become defense E.
Okay, thank you. I'm actually going to show you defense D first, because defense D is the actual demonstration. Can you walk through for the court just how that demonstration took place so that she can get an understanding? Where did it take place? How was it?
Sure. I'll rather stand up and
Whatever you need to do, I just have to make sure that she can see. As long as she can see your own.
we all good. Okay, so Your Honor, arrangements were made for me to fly to Columbia, South Carolina, where the studio would be setting up this production. The setup actually went over a couple of days, and I arrived on the second day. The studio arrangement was indoors, air conditioned, and had video set up from a number of different angles. One was capable of slow motion and all sorts of technical things. The video was shot. While I was there, they began to work on a project which consists of hitting the side of pork out and hanging the side of pork or hanging the side of pork on the front of the backstop board. And there had already been a layout of the physical distances between that board and that target. And Mr. Bratton would be standing to throw the knife set. A set of 6 identical knives, presumptively identical to the weapon involved in this particular case, were available to Mr. Bratton. And then he began to do what he does, and that is throw knives. And I observed him throwing the knives, and then the penetrations, that is, the areas where the knives impaled I then inserted a glove finger to make sure that the tissue, in fact, was a reasonable representation and similar to human tissue that would have been affected in this particular case.
Do you know how many times Mr. Brandon threw the knife that day?
I don't know, I don't remember.
And can you say whether he hit the target every single time?
No, he did not.
And we already, I believe that you already agreed that the distance that was created for Mr. Brandon to throw, it was your understanding that was made by the defense, right?
Correct.
Let's ask that question now. The distance used for throwing was decided by the defense.
That's correct.
In your medical opinion, does the pressure used to cause this type of injury, does it depend on the strength of the person?
In this particular case, with this particular knife, in this particular location, very little strength is needed either for a direct thrusting of the knife with the hand. That would be 6 to 12 pounds. And throwing the weapon just simply adds it's a little bit different than pressure, but it's a ballistic event. And you don't need a lot of strength, and you don't need a heavy knife, and you don't need a specifically designed knife, providing it's not point on. And it doesn't have to hit, it doesn't have to hit point on directly perpendicularly. It can strike point on, below or above the horizontal plane, and still be penetrated.
Now, would you agree with me that Mr. Branson's body size is not similar to Ms. Clenney's body size?
Correct. He was, I think he was 5'10" in height, and he was overweight, and I think Ms. Clenney was proper to be 5'8" and 150 pounds at the time of the incident.
Does that change your opinion, the fact of how the pressure and how it goes in with the knife? Does it change your opinion based on the fact that you watched a demonstration with an individual that is not similar body size weight as Ms. Clenney?
No, I mean, it's qualitatively the same event. It's just a matter of different body mechanics. And Ms. Branton could better address that. I'm not an expert on how people throw knives with novices, and so he could talk about that.
Judge, at this time I would ask to publish Defendant's Exhibit D so we can have Mr. Maricini confirm that was what he observed on that day. I'm going to play this video.
Here we go. If you're just listening, this is the knife demonstration, the knife throwing
Now, when you say
demonstration.
there's no sound here. Do you know if there was sound recorded or not?
We did not get sound recording.
Can you describe to the court, I mean, obviously we can see what's going on, but from your observation as an expert medical examiner, what, if anything, does this demonstration show you?
Well, he threw 6 knives, and he essentially had 3 of them stick, and the 4th one came in and hit the 3rd one, knocking the 3rd one out, but probably that would have been an impalement. Then there was a clean miss, number 5. Number 6, the impact was just barely grazed the side of the carpet. It was not representative. So what we did was, where this, you can stop the previous, go back 1 inch.
Okay.
So what we did was, the knife at the point of impalement, where the skin touched the edge of the knife, indelible marker was used to mark the side of the knife. And then after, as you see here, and then after that happened, the knife was removed and simply put in front of a tape measure ruler to measure the inches of penetration. And so that's what's being happened here. This is you can see that this particular penetration was in excess, close to 5 inches.
And what was, in this case, Mr. Obuselli, the depth of the knife wound? What was that?
It was about 3 1/4 inch, something in that order.
I'm going to show you Defendant's Exhibit C.
Well, that's me, obviously. So what I'm doing is inserting my finger in the defects involved in penetration to confirm that the resistance of the tissues and their general features was similar enough to represent the useful for analysis of the penetrating wound present on this bone solidified.
And you said you did this, what was the result of that, by you putting your finger in there? What did it tell you?
It confirmed that the tissue was a satisfactory representation of the human tissue for purposes of this experimentation.
What are you doing right here?
All right, so let me just show them what I did, and then I'll explain what I'm trying to do here. All right, so now you can stop it there. You can freeze it for a moment. So what I'm trying to do, what I've done is I've inserted the knife and then turned it, rotated it to see if I could find an accessory mark. Now, why is this important? In this particular case,
Who tried to remove the knife?
when you look at the wound as it goes through muscle, fat, fascia, etc., that wound is just an elliptical wound like you expect to see with a knife injury. I can draw it at the whiteboard in a couple of minutes. But the question was, let me come back to it, let me show you our image and then
If you're going to show us something, can you just reference what you are looking at, please?
yeah, we have one of these.
Mr. He's referencing
The picture of the knife is
connection from.
Oh, sorry guys, trigger warning. Wound on the screen.
let me get a color version of that. I'm sure a little bit.
So what you reviewed are the autopsy photos and specifically the wound that was on Albert's belly.
By the way, this is something else that might be useful if you want. Later? Okay, hold on a second. I know I got it here. All right. So this is a picture I'd like to
Well,
show.
it's not in evidence, so,
You want me to hand it to you?
yeah, let me.
You got my copy? And actually, what I'd like to do is these two. Okay. So these two are
Judge, without objection, will be moving defendants F and G in present.
A6 will become defense F, and A7 will become defense G.
I'm going to show them to the court first. And then... Doctor, if you'd like to, you can just reference whichever one you're looking at the time, and you can explain your testimony.
okay. First of all, this is a photograph which gives the general location of the entrance wound. So we don't even talk about it. Sharp force.
And specifically, you're referencing defendant's exhibit F.
Right.
The next
So you
one's
see
real
this is a
close.
elliptical wound. The wound is typically bigger than the knife itself. And the reason it's bigger than the knife itself is that, in my opinion, this defect that we have here is not from the knife just coming directly perpendicular, but from a slight angle. And I can show you a larger image of this.
Why is that important, or what does that have to do with your opinion in this case? the slight angle.
Well, Your Honor, that slight difference doesn't mean a whole lot in this case, except that I wanted to explain size and marks to make it clear what we're looking at. And that would help us with some of the issues we're talking about. All right,
Now
so
looking at defendants G
defendant's A7.
and G.
Oh, no, G, excuse me, I'm sorry. All right, A7 is a larger picture of this hole. Now, this is like 4 centimeters and change in size, and the width of the blade is not nearly that wide. But getting back to the original, why am I doing this to the side of pork with the knife and twisting it? I was trying to figure out this mark right here in the skin that's adjacent to the hole. Now, the hole is like an ellipse. If you look further in, it's a rather narrow elliptical mark. But here, there seems to be more going on with this one end and on. And so I was trying to figure out if that was evidence of a twisting of the blade, either in reference to the state's theory or in reference to what I've been proffered, which was that Mr. Ovensela removed the knife himself from his own chest. So then I was trying to figure out, well, if he did that, well, could he have twisted it, taking it out, because naturally, well, not naturally, but you might expect some difference in.
And I know this sounds stupid, and I know, of course, the logic is she threw the knife, that's how he got here, right? And that's probably how a lot of people sitting on the jury are going to think. But as a defense attorney, and they argued a lot of this at the Arthur hearing back in November of 2022, it's really important to harp on, the treatment. The sutures could impact the way the wound looks when the medical examiner is looking at it to see what was the angle. If the sutures and the treatment are making things swell a little different, the medical examiner might not be able to precisely guesstimate the angle of entry. Additionally, you hear him talking about right now the removal of the knife. Clenney told police, they asked her, did she try to remove the knife? She's like, oh, no, I would never do that. That would be stupid. I've watched enough something to know that you're absolutely not supposed to do that. So potentially there could be a small room for the defense attorneys to argue, and it's their job to do it, that, there was a way that he could have been saved, or that maybe this wound doesn't suggest a direct plunging, but could be explained by throwing from a distance as she was trying to get away and distance herself and keep herself safe. So this might sound stupid, but it's something the defense has to go through.
Mechanics from a throw knife and the removal and so on. But when I attempted to do this duplication, I didn't see a lot that resembled this. It's my bottom line conclusion is that this is an artifact related to attempts to save Mr. Gonzalez's life. And you can see basically some suture holes here where the needle went through the suture material. And it's probable that this is just an artifact of the attempts by the surgeons to save his life. But I went through the extra maneuver of putting the knife and twisting it, and it really didn't look like that at all. When you went twisting the knife, the cut came off at more of an angle here and further up. So this is not from the twisting of the knife blade either. Coming out by either parties. So I wanted to dispense with that in case they continue issuing at a later date. So that's what I was doing with the side of pork after Mr. Brandt had done most of his work.
How did the pig's skin and density compare to the location of the wound in Upper?
Well, I would expect that pig skin.
And objection to the speculation. He wasn't there for the autopsy.
Let me just be clear, from your review of the photos and the records by the medical examiner, how would you say that the pig skin and density compared to human body, first of all?
Well, let's talk about the skin per se. The skin here is processed a little bit to remove the fur. What remains, the epidermal remnant of this skin, is probably a little bit tougher than human skin at this particular site. Unlike the elbows, the palms of the hands, the forearms, and other areas, this area under the clavicle, the skin doesn't have particularly a lot of resistance or as much structure as elsewhere. So once again, if anything, the pig skin per se, in this particular model would offer more resistance, but certainly not less resistance than the skin of a human being at that site, based on my dissections of that area, 4,000 autopsies.
No, you weren't present for the actual autopsy of Mr. Obumseli, right?
Correct.
So you didn't actually get to feel what his skin feels like.
Correct.
But as you said, in your over 4,000 examinations, the skin type differs so greatly.
It doesn't differ that much, and you know, this area is cut through very often because as you may know from an autopsy, there's a wide incision in the front of the body. So we very commonly go through this area to enter the body as part of the basic autopsy procedure. So I have a lot of experience cutting through this area in thousands of autopsies.
The state, you read the examination, direct examination and cross-examination from the other hearing of the medical examiner, and you heard him, his opinion is that this could not have been an injury caused by a throwing of a knife. Do you agree with that testimony?
No, an objection judge said that wasn't his opinion. It wasn't conclude, like, his complete opinion.
I mean, I will rely on my memory of what it is, because I also have a copy of the transcript, but in general, I understand the questions all about it.
Right, it's my understanding that the medical examiner's statement as reflected in the transcript was his opinion. It was his opinion that a knife thrown by this penetrated and caused the woman's question.
And did you
And I
say,
disagree with that for the reasons we just talked about.
okay. And you reviewed Ms. Clenney's statement.
Yes.
Is your opinion consistent with Ms. Clenney's statement that the knife, she threw the knife?
Yes.
If I can have a moment, Judge. I have nothing further.
Okay.
Okay.
All right, so now crossing the Crosserton. Now, as some background with Clenney, there was a lot of stuff going on. She was very skinny, perhaps because of the modeling career. I don't know what we'll get to hear at trial, but going through some of the background and some of her journal notes apps, she has some type of diagnosis where she was taking prescriptions for it, like mental health. She was struggling with an eating disorder. There's text messages around this early spring 2022, or text message rather, not in her notes app, but there's text messages where she's talking with Christian Obumseli, asking him to go get her some snow, some white. So she also, I think in like end of January or at some point, she had gotten a surgery on her shoulder, so she had some pain pills. So there was a whole mix and a half, plus drinking often. So a lot of things in the mix, Peter.
Good afternoon, Doctor. Good afternoon. So first off, you were hired on this case by the defense team.
Correct.
You explained to the court your hourly fees
My actual grade is $600 per hour.
and 2 days, including your testimony today. How many hours have you appeared or worked on this case?
Around 15,000 would be the amount. So do the math.
Okay. So now, this experiment that was done, you were brought in and informed of the circumstances. You yourself were not, outside of the defense team, that's your only knowledge of what happened in this case.
Well, yeah, I mean, I think the statement that the defendant made at some point in time was sort of an approximation. But she was in a room, and they asked her, how far away were you? And she said, how big is this room? And they said around 10 feet or something, words to that effect. And what was drawn for that was an initial 10-foot measurement. So that all of that was proper.
Well, you've seen the video that was just shown to the court. It's your opinion that that is a 10-foot distance?
No, there's a 10-foot range set up, but Mr. Branton has moved in closer for the actual throw.
Can you explain to the court why is it that Mr. Branton threw from 5 feet instead of the 10-foot distance of the room that the defendant stated in her statement was roughly the distance that the victim was from her?
It's my understanding from a proper defense that they revisited the scene with the defendant, or talked to the defendant at some point, and established where exactly she was standing and where exactly Mr. Obumseli was when the event occurred. And they recalibrated opinion that it was about 6 feet.
So you were not there for those conversations,
Correct.
but it's your testimony today that the defense disregarded the defendant's own statement to police and created a different distance based on subsequent meetings with her.
Right, if you want to go back to the video, we'll go over that. But at the end of the day, an adjustment was made based on the defense doing an assessment at the scene of what the actual distance was. And using that assessment, they then instructed Mr. Branton as to what to do.
Are you aware of who was there for that subsequent meeting?
No.
And in regards to the style, and actually, so we're discussing the conversation, the actual statement of the defendant. So not only has the defense disregarded the distance that she says, can we talk about the style in which we see Mr. Branton throwing these knives?
Sure.
And the video speaks for itself, and correct me if I'm wrong, he's stepping forward into it and directly throwing it almost, as a pitching, not necessarily hard.
Right, he's using a different style, and he's using full arm extension at a closer distance. And we had some discussions of what happens at 10 feet. He was doing something a little different at 6 feet.
And why is it that we are seeing him change the style of throw from what the defendant said she threw this knife like in her statement?
Well, I don't know that she gave a lot of particulars exactly how she threw the knife.
Well, you have good knowledge as to the distance that she says. You should also then remember that she said she flung the knife. Right? You remember that?
Well, she said she flung the knife, but to me that doesn't, it's like saying I flung the baseball. I mean,
Well, you
yeah,
also...
I don't know, I don't have a clear idea about how much follow-through or extension is in our arm. And I think Brandon discussed that a little bit in his depo.
Well, when you end up receiving this statement by the defendant, was it the video record statement or was it audio?
I can't remember.
Well, do you remember being able to observe the style in which the defendant showed the detectives how she flung this knife?
I can't remember.
You are in agreement, though, that Mr. Branton has changed the style in which the defendant has shown the detectives she threw this knife.
I would rely upon the view of her statement, the image, the video. I can't remember what the video showed right now. But I would simply compare that video and what Mr. Brandon's done. I don't know what else to say.
Well, you said also you had a chance to review Mr. Branton's deposition.
I did.
All right, and you are quite aware that Mr. Branton says, he can't confirm whether Courtney would be able to throw this knife, if the defense attorney would be able to throw this knife, but he would say that he could at least get the knife to stick.
Sure, that's what he said.
Him being a knife throwing expert.
Yeah, sure.
And you have no knowledge as to the defendant being a knife throwing expert.
Correct.
You'd also agree that, and it's very clear from the video, the differences in body shapes and sizes for Mr. Branton and the defendant.
Yes.
He's got multiple inches on her.
Yeah, he's several inches taller, and he's also probably twice as heavy as she is. So.
And logically speaking, someone who can generate that, or has that much weight to them, would be able to generate a much larger amount of force stepping forward.
Yes.
So the fact that we're looking at the larger than the defendant, taller than the defendant, Mr. Branton, throwing the knife from a different distance than what the defendant says, this experiment is completely different than what the defendant said and the circumstances she faced at the time in which Mr. Angoselli was killed.
I wouldn't say it's completely different. There are some differences. And, rather than me trying to go from memory, I think the court will draw out those differences in time.
Well, that's why I'm here. I can ask you about your memory. So go ahead, tell me, what are these specific instances that are the same?
Well, the weapon's the same.
Oh, let's talk about the weapon. So the weapon itself, did you go and inspect the weapon?
I didn't expect the original.
Why not?
Because I was proffered that the weapon was identical to the exemplars, number one. Number two,
Okay. So I know it's hard to hear, but this is going into, did they use the same knife? And earlier I was like, it looks like the one that's at the crime scene. So now the state is hammering. Did you use the same knife? And did you examine the actual murder weapon, the one that's in evidence, the one that Courtney Clenney threw that night, that evening? And the examiner's like, well, I was proffered about the type of the knife. I didn't look at the weapon. I didn't examine it directly, but I was told I was given an exemplar. So the same example model to use. And it really does look similar. But I'm sure we're going to hear the state say things like, well, obviously a brand new knife is going to be different than the same model of knife that's been used several times and blah, 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 blah. all important arguments to make, even though maybe they don't move the needle for us. You still want to have this stuff laid out in question and answer.
Would not be at liberty to throw the original weapon. Number three, there was sufficient photography of the original weapon to show that the tip was not dented and that the weapon did not seem to have significant wear.
But you would not be able to determine the actual wear, the actual sharpness of this weapon, unless you analyze it yourself. Is that not correct?
It's true.
Right, so you guys, for this experiment, purchased knives that are of the same type. But you did not create the circumstances in which this knife that was impounded, that would have been available for you to inspect, to make that comparison.
I worked at the proffer that there was no substantive differences between the test knives and the actual knife in the event.
You talked about the resistance of the human body, but again, you're not there for the autopsy of Mr. Holmes, right?
Correct.
You don't know the condition of his skin, the muscle density of his body. You could not recreate that in this pig without actually being a part of that autopsy. Right? You cannot guarantee that to this court.
I can guarantee that it's reasonable. I can't guarantee it's identical.
So again, you are changing the circumstances that were faced that day.
Well, we don't do experimentation on human tissue, so we have to do the best we can with mammalian tissue. But yes, it wasn't, 100% identical to that of Mr. Aboso.
And now, have you ever seen or observed the defendant throw anything?
No.
Do you know whether
You don't
or
know
not
how the
she
thrower
threw
throws.
it? No. Do you know? You don't know.
So this is actually a really great cross by Sean Abahoff. I don't know exactly how to pronounce his name. I should probably learn. But you point out all the issues with the example knife that you're using in your test, and now you point out all the issues with the difference between the person throwing the knife to recreate the test and the actual individual involved in the crime. So Courtney Clenney versus the person throwing the knife.
Whether she could generate enough force as Mr. Branton throwing that knife at that pig carcass.
Well, I don't know about the word no. I think it's likely she can. And the reason is, the penetrations that Mr. Brandt got were almost 5 inches. And we only really need 3 1/4 to duplicate what was seen in this particular case.
So again, though, you're saying it's likely. You will have to speculate because you don't know how she throws, you don't know how hard she can throw. And again, you've changed the circumstances and style in which she is throwing your experiment.
I haven't changed anything, but I observed what was done by Mr. Brandt.
And this observation, this experiment was set up by the defense team.
Correct.
You are also quite aware that multiple attempts, the court has only seen one of these attempts at throwing multiple knives at the carcass, right?
I don't know what you've seen. I know there were a number of hours of video talking.
So then you would be aware, you were there for all of it that
Yes,
day.
I was.
And so you were aware that roughly only 50% of the knives, even Mr. Brand, he was only able to get roughly 50% of the knives to stick on that carcass.
Well, in the last video we saw, it was probably close to 4 out of 6, because one knife knocked the other knife out. And then when 2 knives coincide at the same target, they generally interfere with each other, and then you wind up with neither of them sticking. So, but the answer is, let's go 4 out of 6 in that particular run. I'll go with 3 out of 6, that's fine. It's not 100%.
Right, so the knife throwing expert can only get 50% of the knives to stick at a closer distance than what the defendant explained in her statement. She was from Mr. Opensetter.
Right, so that's an interesting point. That means that the defendant had no reasonable expectation of seriously harming Mr. Aboso.
You mean throwing a knife that somebody isn't expecting to? Her allegation of throwing a knife? I would say throwing any knife would be inherently dangerous. No?
Oh, it is. But lethal, you're telling me, and I would agree with you, that it's not a high probability that she would connect. But nevertheless, if it does connect, then you have an individual like Mr. Aboso who's legally injured.
And so you would agree that the experiment that you observed is different than the circumstances in which the defendant faced that day?
It could be. I can't affirm 100% that there's total agreement.
You mentioned during autopsies that medical examiners, cut open this general area of the human body, right?
Correct.
What is the type of device that's used to cut open the human body?
Well, you can do different things. I would typically use a scalpel.
And so the amount of force that's needed to cut open, you can't say that that is what Mr. Branton is using at this in this experiment.
Mr. Brandon. Okay, I'm sorry, could you repeat the question?
Of course. So the amount of force that one would use to have to use a scalpel that could open someone's chest, right there. You can't say that that amount of force is the same that Mr. Brandon uses in the experiment.
All I can say is when I went to cut the skin of this big sample with that knife, that it was almost as easy as a scalpel. So it's a very sharp knife, it cuts very easily.
You mentioned that there are no markings on the defendant's hands for slippage. Again, though, you don't know the circumstances. You weren't there on the date of the incident to determine slippage, whether or not the knife actually slipped in her hand at all when she stabbed Mr. Hillbilly.
No, and what you can say is the converse, that if she was holding a knife and if she was stabbing in the conventional way, that there was no evidence that the knife slipped up, the blade engaged the palm or surface of the hand or any other surface of the hand.
You mentioned for the photograph showing the bruising on the arms, you can't tell at any point in time when those bruises were left or how they were left.
At any point in time, I'm willing to say that the bruising is probably less than a week old, but how recently, I can't say.
And that would be the same for any sort of marking on her neck.
No, not really. I mean, the marking on the neck looks completely different than the bruising in the hands. The bruising in the hands is dense and multicolored.
And could you show the court exactly, this is state or defense exhibit A, exactly where it is that you're talking about this marking on her neck?
I would just ask if I could use the original photograph here versus a copy because it's not as clear in printout.
This is your evidence. So you can, I have no issue with you showing it, but I would just like, I'm trying to have him point to exactly where the court should be looking.
Okay, Your Honor. So we're seeing some discoloration. Step down, so I'm going to advance here myself. So, we look here to see if we can see any discoloration, but more importantly, whether we see any reddening of the skin in these areas. So this is inconclusive. I don't mean to affirm to the courts that this is, I can look at this and say, aha, that's it. But nevertheless, we are concerned about these marks, and there are better images from the collection of images of Ms. Clenney than this particular photograph for both the hand and the neck stuff. So,
But again, though, you have no clue how, if there are any marks, how they got there, or what.
I was asking a proffer, could this be from Mr. Bumsley applying force to the neck of Ms. Clenney? And if the question is could it be, the answer is yes.
So Judge, the only other thing that I would do is, if Your Honor so wishes, we can introduce, we have the other videos if Your Honor thinks you need to see them. Otherwise, I have no questions for you. There's multiple attempts, so Your Honor only got to see one of the attempts. I guess the number of throws, there's, I believe, 4 other attempts at this purpose, to throw knives.
I'd be curious to see.
So, if defense is willing to
No
stipulate,
objection.
okay. So then, we could publish them, Your Honor, or if not, then we could just provide them to the court for Your Honor to review. But
Are they on the same, are they all any the same?
we'd have to mark it.
Okay, so you can publish it and then we'll have it marked as well.
I wonder if this is going to be like the previous bruises or pictures from previous days where she had bruises.
Part of the state's evidence, and they'll apply to different varieties of those videos.
No objection, Judge. I was just saying it's going to be, they're very lengthy if we do it start to finish. I don't know if you can cut.
They're roughly 3 minutes, I believe.
These are videos. I think these might be videos showing bruises on previous dates. Because they did that at the Arthur hearing too. But who knows? Oh, are they just going over the demonstrative again? Oh, it's a different knife thrower. It's their Courtney Clenney. Oh, no, same knife thrower. Oh my gosh, the camera. Maybe they're going to play the police interview when Courtney demonstrates that she flung the knife. Vince, the actual crime was April 3rd, 2022. Oh my god, I wish the camera wasn't so, like, wonky. And there's no jury. This is a pretrial hearing, so, you know, she doesn't need to be in regular clothes.
Very briefly, Mr. Marigini, or Dr. Marigini, I apologize, and if we could pause that really quickly. The way that Mr. Brandon is holding the knife, is that specific to a knife throwing expert?
I don't know the answer.
I'm sorry?
I don't know the answer.
All right, you in your amateur throwing status, first, would you be able to hold, or would you hold the knife in the same way for purposes of trying to stick it into a target?
Well, when I threw it from 10 feet, I held it different.
So the question I have then in that regard, in this instance, do you have any knowledge as to this is in fact the way that it's alleged that the defendant held the knife when she apparently threw it?
I don't know. By the way, just to clarify, even though the left foot is extended forward to here, his belly, the front of this gentleman's belly never really goes past 6 feet. And his center of mass, even though he leans maybe a few inches, doesn't really step through the throw. So it's a forward leaning of the torso, really only a matter of a few inches at most. And the center of mass is basically moving from here to there as he executes the throw. So it's not like stepping into a 1-2 throw, it's still a relatively static throwing there.
So Dr. Marigini, you picked out the pig carcass out of Jesus, right?
Yes.
Did you, when you're making these experiments, doing these experiments, are you replacing the pig every time?
No.
So, in essence, if you're hitting a spot that already has a knife mark, it is easier to penetrate.
Yes.
Because I don't have any questions for the witness.
Stage 1A will become stage 1.
Dr. Maricini, prosecutor asked you about different circumstances that were reviewed in this case, other than
Right.
what
Redirect.
Ms. Clenney said. Do you remember him going over several of those circumstances? Okay, so the first one he asked you about was the way the knife was thrown, and you mentioned that Courtney said the word flung. Do you remember him asking you about those questions?
Yes.
After reviewing the testimony, do you know whether law enforcement or the detectives asked her any follow-up questions to be more specific about what that meant?
It's not my recollection that said specific questions were asked.
No, they asked you about the 10 feet, that was something Ms. Clenney said in her statement, right? Do you recall that the last thing she tells them is they should look at the room,
Yes.
meaning the apartment?
Yes.
Objection, Judge, it's speculation.
I don't know if that's-
No, it's not, Judge, for what the defendant meant in her statement.
Oh, I thought she was asking what was actually said in the statement, and do you recall that being said?
No, the last statement, Judge, was a speculation as to what she meant, whether it be the apartment or
I think you did it now.
Okay. Yeah.
That's your copy. Oh, I just, I'm sorry. That's your version.
What's the division? 8-8, defense 8-8 will be defense H.
Judge will remove evidence when H. Then, Dr. Martini, I'm just going to show you defendant's exhibit 8H, excuse me. Can you just take a look and tell me if this is something that you have reviewed, both pages?
Yes, I reviewed it.
Let me give a copy to the court.
Is it evidence or not?
He's holding the one that's actually in evidence, that's your copy, Judge. Looking at defendant's H, this is the diagram from Courtney Clenney's apartment,
Yes.
and this is from crime scene, right?
Presumably, yes.
You said that in the beginning of your testimony, you did review documents given to you from crime scene.
Yes.
And can you tell us, looking at number 15, going to the second page, what number 15 actually is? What was located there by crime scene?
I'd have to look at the logic, counsel, I wouldn't want to speak for them. Let's see, the global knife is located at 15.
Okay. And looking at the diagram, you listened to her testimony. In her testimony, do you recall where she said that she was by the island and then she threw the knife at Sally?
I would, yes.
And looking at the distance between behind the island and 15, would you say that's less than 10 feet?
I'm sorry, from where did I
If you can tell, if you can't, that's okay. If you're able to see from the diagram that it looks that it is less than 10 feet.
Well,
Based on
the
the,
island looks less than 10 feet in length.
let me ask you this. One of the things she testified to was that Sally started aggressively coming towards her, and that's when she threw the knife. If somebody starts
And
moving,
Judge, so first off, this is outside the scope of my cross. Also, it's called for a speculation.
Judge, I don't think it's beyond the scope because he asked questions about her testimony, various questions about the testimony, and the circumstances that are different, so.
Let's hear what the full question is.
The question would be that if somebody is moving, how the wound, or how the knife, if it was thrown, how it would be consistent with the wound.
Hold on.
The wound that you observed in this case, Dr. Maricini, how was the knife? Was it at an angle? Was it straight in? Can you tell the court what it looked like?
I do apologize. Are we talking about the carcass or are we talking about autopsy?
No, the autopsy of Mr. Alvinselli.
Okay, so the knife wound goes inward, mostly front to back, but slightly from the deceased right to the deceased left.
Can you describe whether, does that mean it was at an angle or not an angle?
Well, it is a slight angle, in my opinion. The ME didn't seem to think so. It's not that much, and it doesn't change any of my treatment, so this is what I can tell.
And if somebody were, if Alvinselli were walking aggressively towards her, would you say that that wound is consistent with somebody doing that?
Objection, there's speculation.
I'm asking you to, based on her testimony, and you're an expert, so you can give your opinion.
I mean, it's consistent with that, but it's consistent with many other events.
Now, you were asked whether, if anybody else could do this other than Brandon, who's a knife throwing expert. Were you present when I threw the knife during the demonstration and it stuck in the carcass?
Yes.
And I was able to throw this knife and make it stick?
Yes.
You don't know me to be a knife throwing expert, do you, sir?
I don't know you that well, Counsel.
And
I'm
your,
just wondering whether they're going to be amending a witness list and maybe testifying as to how much force you might put into that.
your fees in this case, are they in line with an expert who has your same experience?
As far as I know, Counsel.
Have a moment, Judge. I have nothing for you.
The clerk is like, please get this photo away.
Judge, I would ask probably two. In regards to the last questions about defense counsel potentially throwing a knife, was that ever recorded? Do you know?
Well, now unless the video is still running.
Okay. And the circumstances to which she threw this knife, were you made aware of any of them at the time that she threw this knife?
I can't recollect.
And lastly, the exhibit, which I believe is H, the CSI diagram, the item that is marked as item 15, you would have no knowledge as to how 15 got there.
No.
And you would have no knowledge as to whether Mr. Alvinselli was standing right in that specific spot when he was struck by the knife, as alleged by the defendant.
No, I mean, the knife is more or less at the beginning of the blood trail where it's found.
And in regards to her statement about where she's standing, you would have no idea of where exactly around this island to be able to place her on a specific spot on this diagram.
I have no opinion.
I have no further questions.
I added the request for a quick break, so if the witness is allowed to step down, take a 5-minute hunger break, and then
Alrighty. So this feed's gonna cut off. Whew, that was a little hard to hear. That's been this way for this courtroom for like every other hearing we watched, and the camera seems to be really choppy, so that's, you know, who really cares if it's choppy when they're not really doing anything, but it is kind of frustrating when they're showing exhibits, but the camera's like focusing and going like a frame every 10 seconds. But there we go. That is the most recent update. We didn't get to hear much argued about the intent to rely on a battered spouse syndrome defense. There is a status hearing set for November 15th, so I'll keep checking. And Monday, if I get the new exhibit list and see if there's anything of interest, I'll request whatever from that. And maybe this week we can look at that stuff one evening. Yeah, right? Is that it? Short, efficient hearings? Something that we might not be used to, if you're, especially for anyone watching the YSL trial. And no, they are requesting a jury trial, so this will be a jury trial. This is just a pretrial hearing, you guys. But yeah, Dolly might be able to fix her. Oh, the audio. Man, shout out to Dolly. I was also looking, Dolly, doing a Wade Wilson thing today? Is it just hearsay for days that you're gonna, I mean, I'm assuming you're gonna guest on hearsay for days later, right? All right, we'll do hearsay for days as a redirect. And what's really cool about excited utterance, dolly talk, sometimes potentially criminal, hearsay for days kind of takes a look at big cases. So you've got Sarah Boone, you've got Richard Allen, you've got Brian Koberger. But the perspective of the show is to look at the way the conversation on the internet, you know, what are news reporters and weird personalities on Twitter saying? What are the comments in reply to those posts? And really takes a look at, is there misinformation? Is the general public getting it wrong or right? And just dissects the different reactions that are out there about the major trials going on. So hearsay for days is something I think is just a great concept for a show. That's you'll see Dolly on there, but it's really on Excited Utterances channel. So let me link you there in the chat. Right? Okay. So today at 4 p.m. So that's not that far away. We've got I've got football and then hearsay for days. So that's how my day is going to go. It'd be awesome to see you guys over there, because one thing I really think is interesting about a lot of us that watch the YSL trial is, you know, the way so many people are paying attention to it, the way that there isn't like this nationwide coverage of what's going on in the trial unless a super spicy moment happens, like the judge gets recused. But there's a lot of social media reactions. So great parallel there if you're into that kind of thing. Yeah, Mr. I mean, a little bit, yeah, world looks crazier than ever thanks to YouTube. Ayana Davis says the Delphi trial is terrifyingly unfair, and you guys know me, I just like transparency. You know, whether somebody's guilty or not, let there be transparency in the process for the sake of the defendant. If, you know, they have the right to want a public trial, for the sake of the public, their interest in justice, you know, no matter what someone may or may not have done, I think we should have better sunlight on the justice system. And then as far as what we're going to get with Courtney Clenney, sometimes these like status hearings, they get delayed or we don't really get much of an update. They're not always streamed. So there might not be anything exciting from this, but I will keep you guys posted on exhibits. And I'll also share if there's a updated witness list. We can look and see, did they find new expert witnesses? Who are they going to call? We'll have to see. And then let's see. And the other thing too is like, guys, I really think if you want someone to be found guilty, you should want the trial to be done right. Because then you get that word technicality, right? You don't want to set up a situation where someone's trial is so fatally flawed that they appeal and actually overturn their conviction successfully on, and I don't think it's really a technicality. I think that's how the process should work if something was done wrong. But technicality is the word often used. If you want someone to pay for what they did, you want justice for the victim, you think they're guilty, you should want the process to be fair, because you don't want that conviction to be overturned on a technicality, right? So always here for a improvement to the criminal justice system and the process. And with that, guys, this will redirect over to hearsay for days, which won't start for a few hours. But if you want to hit the like button and the notify button and come hang out then, that'll be awesome. And if not, see you guys if you're going to tune in for YSL tomorrow. Forgot it's Monday. I have meetings Monday morning, so I'll be starting around noon, but court itself starts 8:30 a.m. We'll catch up if you want to watch with me. Other than that, see you guys either at Hearsay for Days or on Monday. You guys all have a good one. Take care.